The Zambia Law Development Commission is a semi-autonomous statutory body established under the Zambia Law Development Commission Act, Chapter 32 of the Laws of Zambia. The Commission's primary mandate is to make recommendations for the revision and reform of the law in Zambia. The Commission is also mandated to hold legal seminars and conferences on legal issues. In line with the mandate, today's legal seminar discussion is dubbed Constitution Making in Zambia, Finding the Way Forward. The need for a new constitution in Zambia has been acknowledged by the public for many years. Indeed, some scholars such as the Constitutional Court President, Professor Margaret Munalula, in her article on the 2016 constitutional amendment, dubbed it the 2016 Constitution of Zambia, elusive search for a people-driven process. There has been much debate and discussion on both the process and the content of Zambia's constitution. The constitution building processes alluded to earlier made a number of observations and recommendations with regard to the provisions of Zambia's constitution. Several constitution building processes have taken place, namely the development of the 1964 Independence Constitution, the Chona Review Commission of 1972, which resulted in the 1973 Constitution, the Muvanga Review Commission of 1990, resulting in the 1991 Constitution, the Mwanakatwe Review Commission of 1993, the Mungomba Review Commission of 2003, resulting in the 1996 Constitutional Amendment, the National Constitutional Conference of 2007, the Constitutional Technical Committee of 2011, resulting in the 2016 Constitutional Amendment, and the National Dialogue Forum of 2019. Some segments of the Zambian society saw the 2016 amendment as a significant accomplishment. Other segments felt it could not facilitate transformation and take Zambia to the next level as an independent, sovereign, and democratic state. During the 28th meeting of the 53rd regular session of the Human Rights Council, the Zambian government indicated that it would undertake a constitutional reform agenda in 3 phases. The first phase will involve attending to non-contentious issues. The second phase will focus on the referendum on the Bill of Rights, and the last phase will be to undertake a holistic review on the Constitution. The constitution building processes alluded to earlier made a number of observations and recommendations with regard to the provisions of Zambia's constitution. The 1972 Chona Commission proposed several recommendations aimed at restricting presidential powers, including limiting the president's detention powers, limiting the presidential term of office to allowing only 2 consecutive 5-year terms, presenting 3 presidential candidates from UNIP before the electorate, and creating a one-party state. All of the Commission's recommendations were rejected save for the recommendation relating to creation of a one-party state. The 1990 Muvanga Commission proposed, among others, measures to improve human rights in Zambia, such as preventing discrimination and aligning the Bill of Rights with international obligations. They also suggested limiting presidential terms, making provisions for asset declaration by presidential candidates, and provisions relating to political funding, and establishing a constitutional court. Most of the recommendations were rejected by the government. However, a few recommendations were adopted and included in the 1991 Constitution, such as the inclusion of directive principles of state policy, the abolition of the office of Prime Minister, and the reintroduction of the office of Vice President. The requirement for a presidential candidate to obtain 51% or more of the votes in order to be declared the winner. The ratification of the appointment of the constitutional office holders by Parliament, and the repeal of provisions relating to the leadership code. The Mwanakatwe Commission of 1993 recommended establishing independent institutions to safeguard human rights, promote democratic governance, and preserve the judiciary's independence. The Commission further suggested adopting a suitable method for amending the Constitution and funding political parties, and also recommended reducing the President's powers and expanding the Bill of Rights. The government accepted and implemented a few recommendations, but rejected most of the Commission's recommendations. The rejected recommendations included introducing new personal rights, establishing a constitutional court, improving women's rights, and establishing an independent electoral commission. During this process, the adoption of the constitution was a contentious issue, with civil society groups insisting on a constituent assembly, while the government favored parliament to adopt the final constitutional text. Another point of disagreement was the requirement for a simple majority to elect the president, which civil society opposed. The 1996 amendment to the Constitution was widely considered lacking in popular legitimacy, as it did not consider most people's submissions and introduced controversial clauses, including that of a minority president. The Mungomba Commission recommended guaranteeing 45 seats for each gender out of the 150 elected seats. A mixed member representation system involving the first past the post system for constituencies and proportional representation for additional seats allocated based on the total number of votes cast for each political party. Establishing an independent electoral commission to oversee core functions and the appointment of electoral commissioners through advertisement and selection by a panel of independent experts. The National Constitutional Conference, established under the National Constitutional Conference Act No. 19 of 2007 as a forum for the examination, debate, and adoption of proposals to alter the Constitution as contained in the draft Constitution submitted by the Mungomba Constitution Review Commission, recommended adoption of the Constitution by a Constituent Assembly, Constitutional Conference, or any other popular body that would represent the views of the people. This recommendation was not accepted by the government. Constitutional Technical Committee was created in November, composed of experts who were tasked with drafting a new constitution. The committee's terms of reference included referring to documents such as the Muvunga Constitution Review Commission report, the 1991 Constitution of Zambia, the Mwanakatwa Constitution Review Commission report, and the draft Constitution of 1993. The Mungomba Constitution Review Commission report, the draft Constitution of 2005, as well as the Zloc'S Electoral Technical Report of 2005, the National Constitution Conference Report, and the Draft Constitution of 2011. The committee adopted the recommendations made by previous review commissions and drafted the Technical Committee on drafting the Zambian Constitution. In 2015, the government presented the Technical Committee on drafting the Zambian Constitution final draft, Constitution renamed the Constitution Amendment Bill of 2015 to Parliament for the adoption. The bill was signed into law in January 2016, giving Zambia the 2016 Constitution. The 2019 National Dialogue Forum proposed and adopted various recommendations, including shortening the campaign period, allowing independent candidates to choose from a list of symbols, publishing the election timetable widely, and confirming Zambia as a Christian nation. The forum also recommended forming a coalition government, allowing marginalized groups to enter parliament, reaffirming freedom of conscience, shortening the time frame for hearing a presidential petition, and requiring civil servants to resign 2 years before seeking political office. The forum resulted in the Constitution of Zambia Amendment Bill No. 10 of 2019. The bill was presented to the National Assembly for enactment into law. However, the required support to pass the bill into law was not obtained, and therefore it did not pass. As can be seen, these processes for constitutional reform in Zambia have made some similar recommendations, emphasizing in general the need for urgent reform to the Zambian constitution. However, some of the recurring recommendations submitted to the different commissions remain unattended and have not been adopted as part of the text of the Constitution. The recurring submissions include establishment of provincial assemblies intended to enhance citizens' participation in the governance process at the local level. This was raised by the Muvunga, the Manakatwe, and the Mungoma commissions. The appointment of cabinet outside parliament, which was intended to enhance checks and balances between the executive and parliament and to encourage separation of powers. This was raised in the Manakatwe and the Mungomba commission. The mixed member proportional representation clause aimed at enhancing the representation of marginalized groups such as women, youth, and persons living with disabilities in Parliament. The various review processes advocated for changes that promote inclusivity, democracy, and alignment with the needs and values of the people. They were constituted to create constitutions that prioritize transparency and accountability to the public, encourage citizen participation in governance, and transfer authority to local communities. In order to enhance the possibility of developing a lasting and durable constitution, Zambia's experiences should be taken into account, and a number of questions about the process and the contents of the constitution need to be addressed. Some key questions are: does Zambia require a new constitution? What should the contents of a constitution for Zambia be? What is the rule of law and what are its implications on constitutionalism? What is the most effective approach to creating a constitution? Does Zambia need to hold a referendum on the Bill of Rights? What questions should be asked for purposes of such referendum? How can a constitutional review process enjoy legitimacy?